Austin. I'm here on behalf of the appellant Hunters Point Quarry, LLC. I would like to reserve 4 minutes of time, if I may, for rebuttal.
4 minutes, all right.
Thank you, Your Honor. We're here today to ask this court to take the steps to reverse the Trousdale County Chancery Court's decision in this case. And the Chancery Court's decision was really two parts. First, the court granted summary judgment in favor of the metropolitan government of Hartsville and Trousdale County. And secondly, the trial court affirmed the Planning Commission, the County Planning Commission's disapproval of our client's application for approval of a plot plan for a rock quarry that they sought to build in Trousdale County. That property that they sought the plot plan for was zoned A1, so agricultural. As outlined in our briefs, the Planning Commission here was charged with a very limited administrative task of determining whether the plot plan met the requirements of the ordinance. Again, the Planning Commission here is not the legislative body. Its job is not to set new rules or new conditions or new tests. It's to look at what is in the ordinance and decide, does the plot plan meet the requirements? And the section within the ordinance that you have seen in our briefs probably repeatedly that deals with mining and quarrying activities is section 4.120. And that really sets the development standards and tells the Planning Commission where mining and quarrying activities can be located within the county. There's no dispute in this case that the plot plan submitted met the requirements of section 4.120. The county's contracted land planner through GNRC did a staff report that said it met all the requirements. The meeting minutes from the Planning Commission on July 11, 2022 that are in the record reflects that that individual confirmed it met the requirements. What this came down to was ultimately a discussion as to whether the zoning district, which is again A1, that agricultural zone, permitted mining activities. And what I'm going to back up and say is Trousdale County's zoning resolution, which is what governs properties outside of the city limits, so out in the county for the metro government, not one of the zoning districts specifically says mining or quarrying, okay? So you go through each one, M2, the residential, the agricultural, none of them say by name mining activities. And they list some permitted uses, they list accessory uses, they list special exceptions. I think the county, both before the Planning Commission and in the trial court, does not dispute that mining is permitted in Trousdale County. So there has been no dispute that mining is something that's allowed in Trousdale County. So we're not dealing with a situation of exclusionary zoning, which would be prohibited under Tennessee law. So the only place...
Did you state a separate claim based upon exclusionary zoning in this case?
We filed a writ of certiorari in the case challenging the Planning Commission's decision.
And did you specifically argue that this was exclusionary zoning in this case?
We certainly argued before the Planning Commission and the trial court in the briefing, as I recall, that if the county had excluded mining activity, that would have been illegal under Tennessee law. And but there's been no dispute that it wasn't excluded. And so we get to the Planning Commission meeting where this is ultimately considered. And what happens there is the facts are presented. There is lots of public opposition for this plan, certainly. You can tell from the record. Again, nobody asserted anything, and the Planning Commission did not determine that the plot plan failed to meet the requirements of section 4.120, the location and development requirements. Instead, there was a comment from the chair after the presentation, after the public comment, that the chair had received a legal opinion that the project does not fit the A1 zone. The county attorney was then asked questions about that, asked some questions. And in those very brief comments, what he noted was that the A1 zone does not specifically list mining as a permitted use, an accessory use, or a special exception.
It does specifically list multiple uses though, right? There's a whole list of things I can do with my property in the A1 zone. There's also special uses that are particularly listed. Why isn't that the entire universe of lists of approved uses within this zone? How does mining find its way in when we've got a list of, you can do this, and under special approval you can do this? And I don't see mining under either.
Yeah, and I think that you're right that it's not specifically called out. If you go to section 5.046D, which is the provision related, it's the prohibitory language, right, within a district that says unless the use is provided for, then it can't occur. It doesn't say provided for in section 5.041, which would be the A1 restrictions. The same language is used throughout each district. So what that tells you is from a statutory construction standpoint, you have to, it says unless it's provided for. Well, within the zoning resolution, it is provided for in section 4.120 because that specifically says where in the county it can be located. And leading up to July, and this is in the record, the Planning Commission had a meeting on Valentine's Day that same year, and there was discussion, and the chair concluded, hey, right now with 4.120, mining operations can be located anywhere in the county. Should we think about changing that? In the meantime, Hunters Point files its application. Following the application, the county then does take steps to try to narrow and limit it not to be anywhere within the county that you meet the requirements of 4.120, but within a particular zoning district. And of course, our application predated that, so that doesn't apply to us. But during the July meeting, they had been in June having all kinds of discussions. Should it be an A1 and M2? Should it just be an M2? I don't want it in A1. And so the Planning Commission was very in tune and well aware, and their chair had said out loud on the record with the codes officer confirming, this is allowed anywhere in the county as long as they meet 4.120. And that was right. I mean, that's the only way to read their resolution and not render 4.120 meaningless, which is obviously against statutory construction principles in Tennessee. So then you get to County Attorney Beller's comments in response to these questions. He made the comment that Your Honor and I just spoke about it not being listed by name in a particular category. He also confirmed, consistent with the chair's position and the codes official's position, that mining and quarrying is not excluded from Trousdale County. It's permitted. And then he went on and did an analysis very briefly saying that he had read some provisions and he felt like it was more appropriate in the M2 zone than in the A1 zone.
It had been previously provided for in the industrial zone, correct? That there had been specific reference that mining was authorized there, and then there was a split into the two different types of industrial zones, and the language essentially is taken out. Is that? I won't agree on the exact title of the zone, but I know exactly what your Honor's talking about, and I agree. A long time ago, there had been a specific piece. So are we reading then the deletion of that language as creating the right to mine? So previously, you could have only mined in this zone, this other zone. I'm going to refer to it as industrial.
That's fine.
So you can mine there, you can't mine anywhere else. You delete that language, and now you can mine in agricultural. And that seems odd to me, that deletion gives you a right to mine somewhere you couldn't previously mine.
Well, the legislative body, who the Planning Commission must enact they must live by what the legislative body says, certainly could have deleted, added, amended anything with respect to 4.120. And the legislation, and I do think that we are obligated to give effect to all the words of the zoning resolution. And it's very clear that mining activity shall be located in an area that is sparsely developed currently and for the life of the mine. And we had that affirmative proof there. Like if the legislative body intended to or wanted to take that out, they certainly had the right and ability to do it, and they didn't. And what they did do is after our application was filed, they got with it and started the process to try to narrow it back down. And that's my time. Oh, no, it's not.
No.
I have
you
more.
Can keep going until it gets red.
Yes. I saw it out of the corner of my eye. It's flipped. So at the end of the day, this court should reverse the trial court, because the sole basis for the Planning Commission decision here was that mining activity is not allowed in A1. And that stands in direct contradiction to the statutory construction of it would render that other section, the 4.120, meaningless.
So is there no statutory construction that essentially can say, gosh, the group making these resolutions made a mistake?
Well, legislative bodies certainly can make a mistake. What they can't do is enact something, let it sit there for a long time, and then say, whoops, we didn't really mean to write that in. That's what I would.
Well, we made a mistake, and we left this piece floating out here that instead of just applying to one specific type of zoning area, because we took it out of that one, now it applies everywhere.
Yeah, I think that, at the end.
And surely they didn't mean that.
Well, here's the thing. That, when you look at the development standards, it's not carte blanche. It doesn't say, oh, wow, now you must put up some screen so that rock doesn't fly, or do something to mitigate dust. It's not just that. It has parameters. It speaks to location. It says it shall be located in an area to be sparsely developed. So, we're talking about agriculture whose whole purpose is to be sparsely developed. So at that point, it does have the location parameters in it. It's not like it just said, you've got to put these 6 criteria in that don't have anything to do with location. It said it. So if they wanted to narrow that to a particular zone, they could. It's probably pretty unlikely they're going to get that in a commercial zone that is densely developed, because the development criteria says no, it's got to be sparsely developed. Okay. So,
thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, opposing counsel. My name is Tom Russell. I represent the Trousdale County Planning Commission in this matter. I'd like to start by addressing what is properly before this court and what is properly not. This is an appeal of a writ of certiorari for a denial to place a quarry in A1, which is named Agricultural Forestry District. Council has made the argument that because 4.120 has requirements for mining, but there's no place to put a mine, it's rendering that invalid. And what they argued in their papers was, well, under statutory construction, we should be able to put a mine anywhere in Trousdale County that fits those requirements. I'd like to draw the court's attention to a case. It's Western Farm Products, LLC versus Sumner County. In that, Western wanted to put a quarry in Sumner County. Sumner County had no place to put a quarry. They went before the Planning Commission. That got denied. Appealed it to the trial court. They appealed the denial. But they also said in that, well, if you deny our petition to put a quarry in Sumner County, and Sumner County doesn't allow for quarries, then that's unconstitutional. Trial court affirmed the denial. Comes up to the Court of Appeals. Court of Appeals also said, we agree, you can't put a quarry in this area that's for nature. It then said, with regard to the denial being unconstitutional because that means you can't put a quarry anywhere, that is not properly before this court. And to demonstrate that, in Western Farms, when they filed their appeal of the denial, they filed a second declaratory judgment to answer that question. That was not done in this case. So I believe the court does not need to even consider this statutory construction, how does it affect 4.120. That's not properly before this court under the case I just cited.
So, counsel, your understanding of this case, essentially, there's only exclusionary zoning is only being used as a statutory or as a construction tool. I shouldn't say statutory necessarily, but as a construction tool in this case, as opposed to a separate argument that we have exclusionary zoning going on.
Yes. Okay. Yes, that is correct. And then if you get to, this court knows, but when you're reviewing a denial of a writ of certiorari, that it's got to be arbitrary and capricious and, not material evidence. But there are cases that hold that if it can't be arbitrary if there's a reason for the denial. I cited those cases in my brief. And so we go to this July 11th, 2022 meeting of the board where the Hunters Point puts on a presentation, but commissioners are all there. Public comment is allowed. A commissioner asked Attorney Beller a question of, well, is a quarry a right place to put something that's zoned for agricultural and non-urban purposes? And Attorney Beller said, well, I've looked at the comprehensive plan of this county and the importance of A1 in that. And I think his exact words were, it's like putting, a circle in a square hole. It's just not a good fit for that. Another commissioner asked, well, this M2 industrial zone has been brought up. Would that be a better place? What's very important and was not mentioned before is that Attorney Beller tells the commission that issue is not before us now. Meaning, all we're talking about is putting a quarry in A1, which is reserved for nature.
Counsel, in your brief, you note that there's reliance here on the advice of attorney. Opposing counsel notes that there was public community opposition to the quarry going there. I'm struggling to see how either of those are relevant.
They're
here.
not.
Okay, so this case really is about whether legally there is a right to put the quarry in the agricultural zone or not. Whether if you could have a legal opinion that said it's A-OK,
right.
They could follow it, and yet we still could have a basis here for finding error in terms of how this is laid out, if we reach the determination that under the ordinances.
Correct. All this court is considering, and I think, Your Honor, you nailed this, is whether it was appropriate for the Planning Commission to deny the petition to put a quarry in a zone for forestry and nature purposes. In their brief, they admit that relying on an attorney's opinion is material evidence. You can do that, but there's more in this record, because when the Attorney Beller made the comment that, well, I think maybe M2 may be more appropriate, then they're arguing that, well, now he's tacked on a condition and he cannot do that. Well, if you look at the record, when this was finally put to the commission, Commissioner Noller, and this is from the record, tendered the following, and this is a direct quote: "I make a motion to turn down this project because it cannot be in an agricultural district." He didn't say anything about, well, but we also need to consider if there's other proper places to put it.
So we could have a reading here of the provisions essentially where there is exclusionary zoning that was going on at the time, that this plot plan was filed, but it's not permitted in this particular agricultural area to be developed.
Well, I think you're just looking at,
You're saying the exclusionary issue is not on.
it's not in front of the court, in my opinion. It's a very narrow issue here. Is A1 for nature a proper place to put a quarry? Period. That's what's before the court, and that's what they appealed when that was denied. If you read the commissioner's comments, they don't say anything about, well, we're relying on, is there someplace more appropriate to put this? They're considering the language of M1, that it doesn't say mining is a special or normal use or prohibited use in there, and then they made their decision to deny it. And that's what this case is about. This argument that there's some additional, they have to consider other places, the record simply doesn't support that. And then going to the public opinion, yes, they cannot base their opinion on public opinion. They can't cite to any portion in the record where any commissioner said, well, Mr. Smith was really against this, and I'm really good friends with Mr. Smith, so I'm gonna vote for it.
Ultimately, though, this is a legal question, though, right? I mean, this is not
correct.
Whether it was because of advice, whether it was out of reaction to the community. Ultimately, the question is whether under the ordinances you can put a quarry there or not. And if you can put a quarry there, then there was error. And if you can't, then so the rest of that's just kind of underbrush in a lot of respects.
Yes. I mean, there are other arguments that are in their briefing. They say that the summary judgment was improper. But if you read the opinion of the trial court, they say, well, you affirmatively negated an essential element of their case by demonstrating that, it was not arbitrary or capricious, and when you were relying on material facts, when the commission said, you can't put that quarry there. And
the agricultural zone, the A1 area, specifically lists permitted uses and special uses, and
yes.
None of those include mining.
Correct. And it also says, that exactly, that if it's not listed here, you can't put it in.
And that's part of the language of the A1 section itself, that it lays out that it's either permitted use, a special use, and if it's not in there, then you can't do it in there.
That is correct. I think the court understands kind of what the argument is here, and again, I think it's, all we're talking about is, did the commission appropriately make a good decision, a lawful decision, to not allow a quarry in an area for nature? Was that arbitrary or capricious? My argument is, no, it was not. The language of A1 is clear. Attorney Bella did give an opinion, but the commissioners, for what they're saying, did not consider, we need to say other places. So, like I said, I think the court understands it, and I'm willing to consider any questions or comments.
Don't see any.
Okay. Well, thank you all.
Thank you.
Thank you very much.
What we're saying here is that the commission did not have a basis for its conclusion that the plot plan should be denied that was founded in law. We know that the requirements of Section 4.120, the development standards, which also expressly speak to where mining activity can be located in the county, was satisfied. The land planner said that. That wasn't the basis of the motion to deny. So I think that hopefully that helps answer that question. I would like to go back briefly and hit just a few points. I would refer the court to Jacks versus City of Millington and the Faust case. Those are both cited in our brief. They're cases that go to the concept that you have to construe an ordinance and interpret it so as no part becomes inoperative or superfluous or void or insignificant, and you have to give effect to every provision. And I go back to, the comment about the forestry and agricultural piece. The 4.120 speaks to sparsely developed. You can put a mining activity in the county if you meet the other requirements of section 4.120 and the plot plan requirements, if it's sparsely developed at the time and for the life of the projected life of the quarry. And there was expert proof put on about that. Nobody contested that. It was all about whether or not we can technically keep anything out of any sections. And the exclusionary zoning piece, I will just, say it again, the county, through its representatives, the county attorney at the trial court, everybody has been in agreement that Trousdale County doesn't have exclusionary zoning. Trousdale County doesn't exclude mining. Where they set that is in section 4.120. And in fact, Attorney Beller at the July 11 meeting, and you'll see it, he's analyzing by citing the code section 4.120 and saying, I think it's probably more appropriate in M2. I mean, appropriateness isn't part of the standard before the Planning Commission. It is it sparsely developed now and for the life of the quarry? And there was expert proof on that and nothing to contest it, and their own planner confirmed that it was an agreement, that they were in agreement with that. So on the Sumner County case, I don't think that was in the briefing, the Western Farm Products case. I think that was a floating zone case. It was all about whether that party whether they could operate, whether it was feasible, economically feasible to operate there. That's not our issue here. And at the end, I think we would just ask the court to reverse the trial court and remand the case and instruct the trial court to send it back to the Planning Commission, but with the specific parameters, because there have been called, and that's detailed in our briefing, there have been called into question things like what law would apply. Well, the law is the law of the date of our application in May of 22, and some other things there. But I see my time is up, and I appreciate the court. Thank you so much.
Thank you.